All right, welcome to the Admissions and Financial Aid lecture. This is going to be a short lecture because I want to keep your attention span. So it's going to be really important that you read so you're able to expand upon a lot of the concepts that I'm talking about. Otherwise, you may be lost if you don't read. And these are some very important concepts that we're going to be referring back to throughout the class. So today, what I want us to do is review the legal principles that apply to admissions, and also we're going to talk about the legality of affirmative action and how that fits into admissions. We're going to talk about the legal principles of financial aid, and we're also going to talk about affirmative action as it relates to financial aid as well. So in terms of the basic legal requirements for admissions, the most important concept is arbitrary and capricious, and we've talked about this before. And this is probably one of the most protective concepts for students who are applying to admissions. And when something is arbitrary and capricious, it's when there's no reasonable explanation and something is just done for whatever reason. So you have two students that are equally qualified to admit, and one is admitted and the other one is not, and there's absolutely no reason for the difference. That's an arbitrary and capricious decision. So the selection process cannot be arbitrary and capricious. Now, we also talked about students not having a property interest until they are admitted, because once they are admitted, they now have something to lose. So being denied admission is not considered a property interest. They're not being denied anything because they haven't gained anything to lose. The other thing is contract law. Once a student is admitted, we've talked about that they are entered into a contract, the most basic of which is when a student is admitted, should they follow the prescribed requirements, they will gain admission or gain graduation. Now there's always exceptions to that, the rights of reservations, and a lot of stuff that we talked about before. And then the next thing is non-discrimination. So here students are protected under the 14th Amendment, and it restricts the range of choices. So what that means is that there must be a range of choices, so there can't be strict cutoff points. So for example, if we just had, we're going to admit 30 minority students, okay, there needs to be a range of choices. That does not legally uphold. You can't have strict standardized test scores and saying, okay, we are just going to cut off people based on strict standardized test scores because there's evidence proving that some populations don't test as well as others. So in order to avoid the non-discrimination, you must review applications on a holistic approach. So you got to look at everything as an entire factor. Now, does the arbitrary and capricious standard apply to public and private or both? And that's something I want you to answer when you're doing your readings and as you review the arbitrary and capricious standard. So now in terms of the 14th Amendment and non-discrimination clause, there is a compelling state interest to look at factors outside of specific qualifications such as race. Now, the compelling state interest goes back to the Powell precedent, which I'm going to talk about a little bit more, but in terms of, so for example, a state has a huge interest in increasing the underrepresentation of a specific race to serve a population. So for example, if we look at doctors, and a medical school wants to admit more minority applicants because they are trying to serve a population that is underrepresented. They have a compelling state interest in doing that. And the Powell precedent also talks about diversity being a compelling state interest. So we're going to talk about that more in a second. Now, there's also the Title VI in the Civil Rights Act that forbids non-discrimination. So admitting students based solely on race is a violation of the Title VI Civil Rights Act. So that's where we go back to it has to be a compelling state interest, and there has to be additional factors taken into account because it can't just solely be based on race. There needs to be a holistic approach. Now, the next concept is Section 1981 in contract law. So here, this applies to both public and private institutions, and it guarantees the right for anyone to enter into a contract despite race or sex. And we know that once you're admitted into an institution, there's a form of a contract, albeit weak in some instances, that people are able to engage in despite race or sex. So there again is a non-discrimination clause that somebody can't be excluded to engage in a contract because of race. And then finally, a more obscure non-discrimination regulation is the federal income tax law. And here, those who practice racial discrimination are violating public policy. And if you're violating public policy, then you don't qualify for tax exemption. So a lot of public institutions are tax exempt. So if we threw out the 14th Amendment, Title VI, and Section 1981 and solely based non-discrimination laws on federal income tax, private for-profit institutions could exclude people based on race. However, these other precautions preclude them from doing that, although they may have other ways to get around should they want to. And then there's also the requirement that there has to be some sort of the publication of non-discrimination policies in order to comply with the federal income tax law. So, in terms of affirmative action, this is probably one of the most misunderstood concepts in society today. And the overall purpose of affirmative action in terms of higher education is to increase the number of minority persons admitted to academic programs. And this can create a legal dilemma for some, because how do you justify admitting one person over another solely based on race? And some perceive that as discrimination. Well, in a sense, it depends on how race is being used, and that's the big thing that I'm going to talk about here with Bach's opinion. But there are really two types of affirmative action plans. The first one is a remedial affirmative action plan, and that comes from the word remedy. So I don't want you to think remedial in another sense. So it's from remedy, and that is a mandatory plan passed down from the court. So if we think of the Geyer v. University of Tennessee case, that's an example of a remedial plan forcing an institution to increase their diversity, forcing them to serve an underrepresented population. And the purpose here is to remediate the previous past injustices or discrimination that has occurred and to help eliminate it. The other type of plan is a voluntary plan. And in this case, it's when the institution voluntarily tries to increase a population that is underrepresented. Now, there are two types of voluntary plans. The first one is race conscious, and this accounts for admissions decision making based on some type of preference or advantage for members of an identified minority group. And this is usually more vulnerable to legal action because race can be perceived as the predominant factor, that cannot be the role of race. The other one is race neutral, and this is where race is used as a factor in making is not used as a factor in making decisions about particular individuals. In general, race neutral plans raise fewer legal issues because they focus on factors contributing to diversity as opposed to solely considering race. So, example, if we look at trying to increase a region or a heritage, or we're trying to look at students that may not meet the general GPA requirements and other types of those things, that's supported by Powell's decision, who proclaims that we shouldn't just focus on race and we need to look at the person as holistically as possible. And that's where the two cases that I had you read this week come from. So if this whole concept is a little foreign to you, review those cases again, and that's where you'll be able to get a lot of a better understanding of the different types of affirmative action plans and how race can be a part of an institution's policy to increase an underrepresented population. So something I want you to think about is whether the goal of increasing minority representation, such as race and sex, justifies the admission of differently qualified applicants into professional programs. And this will be the discussion question that I'm going to post, and I want you to respond to this question, but I also want you to respond to your colleagues and your classmates as well. So I keep referring to different cases, the Bach case and the Powell precedent. I'm going to review these now, and these are where we get some of the quintessential legal principles for affirmative action and how we are able to use race in an admissions decision. So to give you a little bit of background, the Bach case was a challenge to the UC Davis admission system where they had 16 slots that were held specifically for minorities, and Bach held that this program was discriminatory and unconstitutional. So what came out of this was that diversity is a compelling state interest. And as we talked about before, if something is a compelling state interest, then that means that the government or the state can have policies or procedures that violate constitutionally protected rights, so long as it is a benefit to the state. But this isn't easily done. It needs to be narrowly tailored. It cannot be overly broad, and it has to be done in the least burdensome way possible. So, what evolved from this was that despite having a state interest, meeting these interests, like I said, had to be done in the least burdensome way. And the Supreme Court reviewed this case and was actually split on the decision and wrote 6 different opinions. But it eventually concluded that the program that UC Davis was doing was unconstitutional, but agreed that in some form race is permissible as a consideration factor. So, what they concluded was that there needs to be less objectionable tests. There needs to be that range of choices that I talked about earlier. You can't just have a definitive number. Okay, you can't have rigid quota systems that say we're going to admit 30 Hispanic students and 15 African Americans and 20 white students. You can't go into an admissions policy thinking that. Additionally, you cannot have separate systems that evaluate minority applications with procedures and criteria different from those used for minority applications. This goes back into having a dual system of higher education, and that was not permissible. Next, they agreed that race can be used, but only as a plus factor. It cannot be the sole determining factor for admissions. So like I said, when you have 2 people that are equal, you cannot admit one over the other simply because of his or her race. They have to be reviewed holistically and see what they will bring to the campus as a whole, not just on what does the color of their skin bring to the campus. And this leads us back to the Powell precedent. And the Powell precedent defined for us what the student body can look like and how there's a compelling state interest. And essentially what the Powell precedent said from the Bach case was that the state interest is more than a percentage of races or ethnicities. The student body is many different qualifications and characteristics and cultures and languages and international experiences and community service, personal and life hardships. It's a whole bunch of things, and race is only one. So it doesn't make sense why we use race as an objectionable test for admission when the student body is so much more than that. That's why when we get into individualized comparison, race does not equal diversity. There needs to be a difference there in understanding that race is not solely the defining factor of diversity. There's so much more. And then that gets us into the differential admissions policies. And racial classifications can serve a purpose to provide context to lower test scores when considering their established academic inadequacies and predicting academic performance. So it's important to understand race as a context. We know that African American students tend to score lower on standardized tests for various reasons. So to use that as a context is appropriate, but to have a separate system with different criteria based on race is not appropriate. So there's this fine line in recognizing academic inadequacies, using race as a context, and yet upholding the student body. And like I said, the reading and the cases that I've given you will help expand on these different premises.